I am Martin F. Loughlin, and I am interviewing a former Supreme Court Judge, William Batchelder, and I'm going to be informal here and call you Bill instead of Judge.
Appreciate that.
And I'd like to go over your very distinguished career. I'd like to start off with where you went to school and where you were born and some background.
I was born in Plymouth, New Hampshire, and went to the public schools there. Like yourself, I was a child of the Depression and World War II, and I can remember the public school system in Plymouth. It was a little separate and distinct from the rest in the state for the simple reason that we had a teachers' college in town, and the town had contracted the elementary schools services over to the teachers' college. So during the first 8 grades, we had the benefit of a teacher and a number of student teachers. And then I went on to high school in Plymouth.
Okay, and what year were you born?
1926.
1926.
And I never really graduated from high school. And I think the world should know that I didn't finish high school.
Okay.
It was at a time in 1943, 1944, when we were permitted, those of us who chose to, in anticipation of going into service, of getting out of high school after 3.5 years and going to the University of New Hampshire. They accepted us. So I left high school in December of 1943 and started college at the University of New Hampshire in January of 44. The downside was that we were picking up the second semester courses that others had had the benefit of doing in the first semester. So we walked into college mid-year. There were 3 of us from Plymouth High School who did that, one of whom was George Ray, a member of the bar in New Hampshire for many years, who passed away this year. And then we completed the first year of college at UNH by attending summer school. So we went college in January, summer school into September, and October into the Navy.
All right. When you got out of the service, Bill, what law school did you go to?
Well, I still had to finish college when I got out of the service. Mm-hmm. And probably I wouldn't have done that but for the GI Bill of Rights. But the GI Bill made it possible for me to complete college and go to law school. The GI Bill was signed by Franklin Roosevelt on the day my high school class graduated in 1944. So I finished college. Then I went to Boston University Law School in 1949, and we were the second group in the country to take the LSATs. And they were given a lot of publicity at the time because I can remember reading in Time magazine some of the questions that were being asked on the LSATs. You know, the syllogistic reasoning kinds of questions, which were interesting to read, and I found out that I was taking those shortly.
There were some members of the New Hampshire bar that were in your class. Would you mind mentioning who they were?
Sure. When I was in college, I had no vision of going to law school. My father was a janitor. My mother was a kindergarten teacher, and law school was not big on the family agenda. But I was in a constitutional law class at the University of New Hampshire, The professor was Norman Alexander, who was a lawyer. He was a very, very fine man. And he encouraged me to go to law school, which, tells us that in your life there are teachers who really play an important role. But some of the people in that class were Arnold Hanson, George Ray, and Shane Devine. In fact, I think we all sat in one row in that constitutional law class of Professor Alexander's. And it was a great course. He was a very, very inspirational teacher, and he's the one who aimed me toward law school.
Right. Now,
he was always impressed by the fact that Arnold Hanson ate oatmeal every day. And that impressed Professor Alexander immensely.
well, he's from Berlin. I
That's
can understand that. You graduated in 1952?
Yeah, yes, from law school in '52.
And when were you admitted to the New Hampshire bar?
I was admitted in, I think, September of that year. I really didn't have any intention of practicing here. And I took the bar exam in Massachusetts. The scheme in mind at the moment was that I would practice down somewhere in the South Shore with a friend of mine from law school, who later became a Superior Court judge in Massachusetts, Cortland Mathers. So I studied for the Mass bar, and the year I took it, there were 700 of us, between 700 and 800, and 260 passed. And what had happened was, apparently the Board of Bar Examiners had determined that it was a good time to weed out a lot of perennial bar exam applicants and takers. So what played in my favor was, and I will never understand why I ever did this, when I was in law school, I took an elective in the law of future interests. It's not a course that's highly sought after today. The Mass bar exam that year consisted of 24 essay questions. We did it at Boston Latin. 12 each day, 6 in the morning, 6 in the afternoon, 2 days and out. Of the 24 questions that year, 5 of them related to the law of future interest. So I passed the Mass bar and got admitted. After I had studied and taken the Mass bar, I came home, and George Ray told me I should take the New Hampshire bar, and I said I hadn't studied for it. And he said, well, he had taken the bar review course, and that they were having a review of the review on some particular night that week, and Ted Gallagher was teaching the course. So I attended the review of the review. I took the New Hampshire bar and I passed it as well. And Ted Gallagher claimed, at least in appropriate times and places, he used me as a selling point for his bar review course.
Did you read Moynihan's book on future interest?
Yes,
Yeah.
Cornelius Moynihan.
Yeah. Bill, I'd like to get into some of the early cases that you had as an attorney up in Plymouth, New Hampshire, and I'm going to kind of lead you into it by just mentioning certain words. One, the word mortgage, if you could expound on that.
Mortgage case?
Yeah.
What happened to me was the situation at South Shore didn't work out, and I had my neighbor across the street in Plymouth was Bill Maynard. He had a practice in Plymouth, and I, in effect, I guess, clerked for him for a couple of years when I was in law school in the summertime. And, I gravitated into his office after I passed the bar, and I was just with him for about a year and a half because he and Morris Bois, after the Eisenhower victory in '52, Morris and Bill became the U.S. attorneys in New Hampshire. And Bill left Plymouth, and I had a one-person law practice for a few years.
No.
So it was at that time that I did these things. I was on the board at the local hospital, and we had a woman who worked in laundry. Her name was Jessie Kachelik, and she had had...
Can you spell it? Do you remember? No.
I can't.
All right. Okay.
Begins with a K. She had signed a contract with an outfit to have sidewalling put on her house. Her house at the max was probably worth $3,500, and she'd put on about $4,000 worth of siding on it, and signed a note, and she didn't make the payments. She was way in over her head. She never, she was sold a bill of goods. The job was terrible. But she found out one day that she'd received a notice of a mortgage foreclosure, which was advertised in the local newspaper, and she'd received the appropriate in-hand or registered mail notice. And she came to see me. What had happened was, when she signed the note for the sidewalling job, she had authorized someone in the sidewalling company's hierarchy to mortgage her property. And lo and behold, the person foreclosing the mortgage was none other than former New Hampshire Supreme Court Judge, retired John Goodnow. Judge Goodnow left the court, I think probably because he wanted to get back into the private sector and make the money that was available in the private sector that wasn't in the judiciary. So here I was, fresh out of law school, and I find myself tangling in one of my early cases with a retired New Hampshire Supreme Court judge.
He was from Keene, wasn't he?
Yes.
Yeah.
I think the firm he founded became Goodnow, Arwey, and Eyre.
Yeah.
So I did what any young law school graduate would do. I found something to hang on, and that was, I love this language, the doctrine of equal solemnity, which stands for the proposition that if you're going to sign an instrument through a power of attorney or agency that has to be acknowledged, sealed, and witnessed, then the underlying document must be signed with the same solemnity. It must be signed, acknowledged, and witnessed and sealed. Needless to say, in Mrs. Kachelik's case, all she had signed was a note authorizing these people to put a mortgage. So I made this claim to Judge Goodnow, and boy, he swallowed hard. He did not like what he was hearing, but he knew it was the law, and that was the end of Mrs. Kachelik's problems. My memory is I did not get paid for that, but what it did happen was every Christmas Eve until that woman died, she called us and wished us a Merry Christmas. Every Christmas Eve. My kids, the phone would ring on Christmas Eve, and my kids would say, "It's got to be Jessie Kachelik."
Now I'd like to direct your attention to another case, Squam Lakes Club.
Oh, there was a time when people began to sniff around the lakes with a view toward substantial land subdivisions. And some people got together and formed a group called the Asquam Lake Ski and Beach Club. Pretty high-sounding name. And they had bought a big parcel of land down at the southernmost end of what is Dog Cove. Hugh Bounds, Judge Bounds of the Circuit Court, practiced in Laconia. I practiced in Plymouth, and we collaborated on this case because we were engaged by the towns and some of the lakeshore owners. I think I represented the town of Ashland and the town of Holderness, and I think Hugh Bounds represented Center Harbor, Moultonborough, and Sandwich. And we each had some private clients as well. John Nasikas represented the developer, and this wound up with a trial, jury waived, in the Belknap Superior Court. And we worked out a stipulation with the developers. Judge Bounds and I can remember we used to go down to the Winnisquam house and have lunch, and we'd work on our requirements for the stipulation over lunch. So we scratched these things out on whatever we had available. And the developers signed on for the cruise. It, in effect, precluded them from ever developing the property because our restrictions were so tight. But Judge Bounds and I learned later that some appropriate state agencies seized on our stipulation as the basis for the first environmental protection standard for the lakes in New Hampshire. It was, you know, the law of unintended consequences. We represented some clients and protected the interests of the property owners around the lake, but there was some fallout from that that made us both feel pretty good.
John Nasikas was with
Yes.
an Nuri, was he?
Yes.
And yeah.
And he later became a federal trade commissioner, didn't he?
Yes. Bill, I'd like to direct your attention to the Plymouth High School case.
Well, first off, I practiced, my practice was limited pretty much to personal injury cases and representing municipalities and handling real estate transactions. I did not do probate. I did not do taxes. I did not do agency appeals. I stuck pretty much to those basics. And there came a time when the state was seeking to create more centralized schools. And there were two ways to go. One was a cooperative school district, and one was the so-called area school, which stands for Authorized Regional Enrollment Area. In order to accomplish either one of these two goals, there has to be a consensus between the receiving town, that is the town receiving the students, and the so-called sending town. I was asked by the superintendent to appear before the Warren, New Hampshire school meeting. That's Norris Cotton's hometown. So I appeared this particular night. There was a special school meeting, and they transacted whatever business they had to transact. I had my new associate with me, Walter Murphy, who's now a Superior Court Justice. And Walter and I went up, and after the locals had transacted their initial business, the superintendent got up and introduced me as the attorney for the Plymouth School District, who was there to speak about Warren joining a cooperative school, at which point we emptied the hall. Everybody got up and walked out. That's not a big ego builder for a lawyer, but it was pretty demonstrative of the attitudes in those small towns at that time about joining in a cooperative or area school venture. Plymouth went down the road. We went through this for 2 or 3 years. We tried to do a cooperative school, and we'd have the big vote, and 2 towns would vote no, and the others would vote yes. And we tried the area school. That went down. Third time around, we did have enough towns to put together an area school. And included in the group was the town of Rumney. Now, at that point, a new person had appeared on the scene, and his name was Meldrum Thompson. And he had come here from New York, and from, I guess, into New York, but from Georgia. He was in the law publishing business, had his place over in Orford, and he was seeking some kind of a public presence. And he formed a group called the Public Schools Association. This was his first entry in New Hampshire into politics, and he received great support from the Manchester paper. There came a time for Plymouth. Our school was designed now. We had the towns, and the bond issue had been granted, and we were ready to put the job out to bid. We did. There were no problems. Then the town of Rumney, at the urging of Mr. Thompson, opted to withdraw from the plan. That resulted in litigation that went to the New Hampshire Supreme Court, and Rumney was required to stay in. We had then reached the point that we were going to lose the contract because the contractor had about 30 days or 90 days left to get started, or we would have to put the project out to bid again. And Governor Thompson had advised these people, and he wasn't governor then, to take an appeal from the New Hampshire Supreme Court to the United States Supreme Court on the basis of Baker versus Carr, one person, one vote. I've often wondered whether they really intended to go to the U.S. Supreme Court. But they knew that the time period was such that we would lose the contractor in the process, and we'd lose the whole school. So at that point, lawyers have to be energetic, honest, and innovative. And that was before Fuentes. And Walter Murphy and I brought suit on behalf of the Plymouth School District against the principals in Rumney who were engineering this appeal to the U.S. Supreme Court on the basis of interference with advantageous business relations with the contractor. And because it was before Fuentes, we attached the bank accounts of all these people. We attached their real estate. We attached their vehicles. And we brought a very hefty lawsuit claiming that they were in this to obfuscate our having the new school. We asked for them to post an injunction bond, and I can remember going down to Exeter and appearing before George Richard Grant, Jr., and we made our presentation. Judge Grant was pretty quick with a pen. He said, "How much do you want for a bond?" We said $300,000. He said, "Granted," and that was it. Needless to say, they didn't put the $300,000 up within the prescribed period of time. The appeal to the U.S. Supreme Court never got launched, and we have a central school in Plymouth now.
Okay.
That was an interesting project.
It was. One other case as an attorney was the Eastman Pond case.
Well, that actually wasn't litigation, but that was the last real estate transaction I handled before I went on the bench. We represented the then owner, the Draper Corporation from Hopedale, Massachusetts. And this was supposed to be, you know, the designer, environmentally secure subdivision. And I hesitate to say who the principals were. I believe, my haunting recollection is that Dartmouth College, the Hitchcock, a Manchester bank, and an insurance company were the four principal owners at that time. And they were going to use this as the, you know, the hallmark, the guide for all future land subdivisions in the area. Whether that worked or not, I don't know. But it was a substantial real estate transaction, and it was the last one I handled.
Bill, in New Hampshire, going back to our day, not Maureen's, we had a lot of judges at the municipal level who were lay people. And can you tell us an interesting story about a Judge Ernst?
Robert John Ernst was the municipal court judge in Plymouth. He was a professor at Plymouth State College. He was a professor of business practices. He was a good, decent, honorable man. He was not a man of great patience, and he was not a man of great humor. His appearance in court, perhaps described in terms charitable to him, would be to say it was severe. I appeared before him in a drunk driving case which had come to me right after our Supreme Court had decided state against Riensterner. And Riensterner was the case that stands for the proposition that to get the blood alcohol results in evidence, the burden is on the state to show the continuity of the evidence from the time the blood is taken from the operator. In other words, the state had the responsibility of proving as an element of the offense, or well, not as an element of the offense, but proving the authenticity of the sample before it could be admitted in evidence. They had to get it from the defendant's arm to the lab and the report to the court. So this was such a case. And what I had done, George Chauvin was the clerk of the Supreme Court at that time, and I think I actually drove down to Concord and got a copy, got the advance sheet the day before it came out. I can remember they were, in those days, typed on yellow paper. You couldn't miss them. If they were on your desk, you knew that was one of the advance sheets. So I had the advance sheet of State versus Riensterner, which would not permit, under any stretch, the blood alcohol to get in evidence in this case that I had. So the state put its case on, didn't establish continuity. I moved for dismissal, and I handed Judge Ernst a copy of Riensterner. And I said, Judge, I'm afraid you're going to have to dismiss this because the state hasn't sustained its burden of showing the continuity of the evidence. He read it. My hunch is he then read it again, and he said, "You going to put on any evidence, Batchelder?" And I said, "No." He said, "Your client's guilty." I said, "What about the Supreme Court decision?" He said, "They're wrong." So much for trying cases in the municipal court. You know, we took an appeal to the Superior Court, and that was the end of it. But I think any lawyer who practiced in municipal lay courts had similar experiences. There's a great story about the district or municipal court over in, I think it was Enfield. A man by the name of Stewart was the judge, Judge Stewart. Actually, his daughter went to college with my wife. When Judge Stewart sold his house, the buyer was a fellow from Massachusetts. His name was Vince Aguirre, and he was a window dresser. He ran around and put all these fancy designs in store windows and did displays for people. And Mr. Vince Aguirre convinced the real estate people that he would buy this house from Stewart if Stewart would arrange for him to become the judge, because, you know, all the files were in the house. So somehow they made an arrangement with then Governor Donnell, and Judge Vince Aguirre became judge of the Enfield Municipal Court because he happened to buy Stewart's house.
You know, an interesting sidelight on Riensterner was defense counsel was John King, who later became governor.
Right.
Yeah. Now I'd like to move on.
And Chief Justice.
And Chief Justice. Now I'd like to move on to your time as county attorney for Grafton County, and I'm going to lead you into the fellow named Henry Greenlaw.
Henry Greenlaw was another lay judge. He was a judge in the Bethlehem Municipal Court. The chief of police was a man by the name of Howard Sanborn. He was a nice man. Henry Greenlaw used to sign search warrants in blank and leave them in his desk drawer. So when Howard Sanborn wanted to make a search, he didn't have a lot of formalities to contend with. All he had to do was open the desk drawer in the judge's desk, take out the signed search warrant, and fill in the necessary blanks and go ahead and execute the search. Now, when Potter Stewart wrote Coolidge in New Hampshire,
Supreme Court.
yes, U.S. Supreme Court, he, of course, hung the case on the constitutional requirement that there be a neutral and detached magistrate. But I can't believe that he had the extent of detachment that was involved in Henry Greenlaw signing the search warrants in blank. But these things happen, and that was, an interesting sidelight in my work as county attorney. I know that.
The next case, Bill, brings back memories to me because I happen to be the presiding judge, and that's State versus Albert Healy.
Yes, I prosecuted Mr. Healy for murder, 2 counts, because of arson. He had ignited. This shows you, what happens when bad things are set in motion. He set a fire in some back alley in Lebanon that got out of hand, and it actually wound up consuming about 25% of the major part of downtown Lebanon. All the wooden frame buildings and stores were just leveled. And in the process, 2 elderly men in some local rooming house were burned to death in the transaction. I can remember learning that people who are arsonists like to be around when the fire's going on. And I went to the state police detective, went over to the Valley News, which was published, I think, in White River Junction, and went through all the pictures they had taken during the Lebanon fire. This was a humongous fire. And I can remember we looked through hundreds of pictures. One of the stores that was consumed in the fire was Fletcher's paint store, which was on the main street. And the fire department was very anxious to get the paint out of the store because they were afraid of an explosion. And people were actually handing these gallon cans of paint out like a bucket brigade. And right in the middle of that one picture was Albert Henry Healy, present at the scene, helping get the paint out of the store. I had a police state, we had the luxury of time and energy in those days. I had a state police detective assigned to me that summer. All he did was check on Healy. And I was prepared to cross-examine him were he to try the case. And I knew more about Henry Healy than he knew about himself, I think, at that point. We learned, among other things, that Healy had worked at a hospital, at the Mary Hitchcock Hospital, and while there he had set some fires, but they didn't want to report it because they didn't want to get involved. We learned that probably he had set a half a dozen fires in the outskirts of Lebanon. But make the long story short, he went through all the motions of going forward with a trial. As you know, you were prepared to try the case. And at the last minute, he pled to second-degree murder, and so far as I know, probably spent the remainder of his days in the New Hampshire hospital. I think he probably transferred there from the prison. But the defense did not raise insanity. And the state's examination indicated that he probably was all right at the time he set the fire. That's something we'll never know.
It was Fred Catalfo.
Freddie Catalfo represented him, yes.
What I found interesting about that case, Judge, was that it was the first capital murder case. It was originally a capital murder
Yes.
case, yeah. Before we move on to your appointment to the Superior Court, I'd like to get your viewpoint, both as county attorney and as a practicing attorney in New Hampshire, about New Hampshire juries.
I think to sum these experiences up or encapsulate them is to say that over my years trying cases as a lawyer and presiding over cases as a trial judge, I came to have enormous respect for the jury system. It makes you feel good about your government to see people take seriously and with public spiritedness the role that they're asked to play, and they do it well. Sure, there are mistakes, there are aberrations, there always will be along the way, but there are ways to accommodate the mistakes. But on balance, the juries tend to get it right, and they bring a lot of different life experiences into the courtroom. And these life experiences, I think, are great aids to them in sizing up the credibility of the various people they see sitting on the witness stand. I have great confidence in the jury system, and I think it's one of the great features of our form of government. And I shudder to think that someday it may be changed.
Bill, let's move now to, I think, was it Governor Peterson that appointed you to Superior Court?
Yes, Governor Peterson appointed me to the Superior Court in 1970.
Mm-hmm. And you had some reference to an experience you had with attorney, the late attorney, James Sullivan of Nashua, New Hampshire.
Yeah, I think every judge, whoever he or she may be, you have one memory about, and that's that first case, the first time you do something as a judge. And I was assigned to Nashua, the Superior Court, and I walked in to the old Nashua courthouse. Nashua was in the midst of a school teacher strike, and no teachers showed up, and the schools were flat. Everything was shut down. There was an elementary school teacher. She might even have been a kindergarten teacher. Her name was Moriarty, I remember that. And she had been let go the previous year. Apparently the school board or the superintendent or some administrative authority had determined perhaps she had spent out her usefulness to the system, and they were prepared not to renew her contract. She was represented by Jim Sullivan. And I can remember seeing the Nashua paper. My memory tells me that here the schools are all shut down. One teacher shows up, and it's Miss Moriarty, who didn't get her contract. And she's driven up in a taxi with Attorney Sullivan, and she's standing on the schoolhouse steps, ready to go in and teach. So her problem was the fact that she claimed the notice was somehow infirm that had been given her by the administrative authority in terminating her contract. And I listened to the evidence, looked at the pleadings, looked at all the notices, and I found that a case could be made that the notice to her was inadequate. And she said, "Judge, all I want is one more year, just one more year." and I found that she was entitled to that one more year. So I found that she had a job for that year, and that made me feel good, got good press, made the court system look good, and she felt good. That was it. I went back there the following September, and the first case that was put on my desk was Miss Moriarty, who came in and said, "Judge, I want just one more year." And she had made the claim the second time around that even that notice didn't quite cover the waterfront, and she didn't make it that time. But it was an interesting experience. I take my hat off to a lawyer. I mean, he gave it everything he could.
That was Jim Sullivan.
Jim Sullivan,
Yeah.
a fine man, good lawyer.
Yeah. Bill, I'd like to direct your attention to a very infamous case. I happened to be on the Superior Court when Judge Griffiths tried it, and that's the Coolidge case. And could you tell us how you got into it and some background on it?
Well, of course, I think, you know, the U.S. Supreme Court reports tell us pretty much what happened. During the investigatory stages of the underlying action, Bill Maynard was the Attorney General, and he signed a search warrant to search Coolidge's home for weapons and other pieces of evidence. You have to know that historically, that was done routinely by prosecutors in New Hampshire and had been. The only requirement in the issuance of a search warrant was that the warrant be authorized by a justice of the peace, and Maynard qualified. So he did what all his predecessors and all the county attorneys or county solicitors in those days did. He signed a search warrant based on information given him and an application by the appropriate police authorities. And of course the case went to the U.S. Supreme Court. It's interesting to note that that probably was one of the first cases where there was a substantial pro bono contribution from the big Manchester firms. Coolidge was represented by Matthias Reynolds, Bob Chiesa, and John Graff. They had been, their services had been donated by the Booth firm, the Devine firm, and the McLean firm. And they practically devoted full-time energies to the Coolidge case.
Bill, if I could interrupt,
Sure.
I happened to be on that case for motions, and Mary Devine, remember that? Mary was originally appointed and died.
Yeah.
Yeah.
I did not know
Yeah,
that.
that's.
Well, in any event, after the trial where Coolidge was found guilty, they went to the U.S. Supreme Court on the basis of Maynard's search warrant, and the case was argued down there by Archibald Cox, who prevailed, and the case was, the verdict was set aside because we'd mentioned this earlier, that Justice Stewart had said that search warrants must be signed by neutral and detached magistrates. Bill Maynard did not fit the bill. He was the Attorney General, and hence a new trial. So I came on the Superior Court, and I was flattered because Chief Justice Keller, I was, fairly new. I had been on the bench a year. He asked me to take the Coolidge case for its retrial. And that case involved some very sophisticated evidentiary gathering techniques in the precursors, I guess, mechanically to something to DNA. I mean, it was not the kind of evidence that DNA is, but the technology was not that far apart. And that was called neutron activation analysis. Pieces of matter could be taken. In this case, they were taken down at MIT, and they were put in a cyclotron, and they were subjected to this great infusion of neutrons, and then an analysis is made as to how these neutrons dissipate. And every piece of matter, apparently, the diffusion of the neutrons is at a different rate. So scientists in the case were prepared to say that, they could take 1,000 people, take a hair from each one of them, cut each one in half, and then through neutron activation analysis they could match up the pieces and get it accurate. So I listened to all the pretrial motions about neutron activation analysis, and I listened to them being presented by two New Hampshire lawyers, Warren Rudman and David Souter. Warren was then Attorney General, and David was either deputy or assistant at the time. And there had been a change of venue in that case. I was going to try the case in Laconia in January, and during the holiday week, just prior to New Year's, I got a call from the Attorney General's office that they had agreed to accept a plea. And the plea was a very, very substantial term of years. I think 25 to 40. Of course, Coolidge had served some 7 pending the appeal. But the plea was taken. We did it in the Merrimack County Courthouse because there was a fear that there would be too much of a ruckus here in Manchester. A lot of demonstration. Warren Rudman and David Souter were present in court along with the 3 counsel, Coolidge. And I prided myself, I guess, at that point in the knowledge that Furman in Georgia was in the pipeline. And I made it clear when I took Coolidge's plea that if he were to have tried the case, he would not be subjected to a more severe penalty, that is capital punishment, than the life sentence given him in the first case. I made it clear to him that he could be, his penalty could be enhanced only if during the intervening period between trials he had been of bad behavior, or if on the trial of the second case the crime appeared more heinous than it did in the first. I said that just couldn't be the case. So that was buried in the plea taking. And the plea was taken, and then in June, down came Furman in Georgia, and then came an array of appeals from one end of this country to the other, where prisoners were asking that their convictions be set aside because the only reason they had pled guilty was to avoid a harsher penalty in another trial or to avoid capital punishment. And I feel that the state was a beneficiary of some good legal research on the part of all of us involved in that case.
You want to take a break? Okay. Bill, I'd like to go back to the time you spent in the Navy. I think you said it was in 1944. You want to tell us a little bit about that?
Well, yeah, I went in the Navy in November of 1944, and I spent my boot camp at Great Lakes Naval Training Station on the shores of beautiful Lake Michigan in the months of November, December, and January. And then I wound up going to electrician's mate school in Gulfport, Mississippi. When I was in Gulfport, I think I opened up the first chapter of a liberal education. I was going over to the 3rd Air Force Base at Biloxi to visit a high school friend. And that was a big B-29 base where I'm sure the Enola Gay probably had trained. And I got on a bus in Gulfport, and I sat in the back seat, and nothing happened. And nothing happened, and nothing happened. And finally, somebody came back and said, in effect, "You must be a damn Yankee. This bus isn't going anywhere until you get out of there, because that seat is reserved for," and they used the N-word, Major League. You know, coming from Plymouth, New Hampshire, that was an eye-opener. And then I saw that situation really closely over the next few months down there. The ship, I was assigned to, there's a lot of fortuity, as everybody knows, in the military. Everything is done alphabetical. I was in a barracks, you know, Batchelder, you're up at one end. There was a fellow named Abrams and a fellow named Alexander in the bunks next to me, and a fellow named Baggett at the bunk over me. He was from Georgia. And it came time to move out, and I was assigned to a seagoing tug in Oakland, California. And Alexander, who lived in Oakland, California, was assigned a destroyer escort out of Boston. And being imaginative, we went to see the yeoman in the office, and all he did was just switch the names on the papers, and I got the destroyer escort on the East Coast, and Alexander got the seagoing tug out of San Francisco. I think Alexander might have come out the worst of it, because there was a typhoon in the Southwest Pacific that year, and the cruiser Nashville was almost broken in half in the typhoon, and Alexander's seagoing tug went down and towed it back to San Francisco. Probably at about 6 knots, and so it's a long trip. I went out to sea in the North Atlantic when the war was over, and I was on this little destroyer escort. We were screening for an aircraft carrier, which was a baby flat top, small carrier, the USS Card, and we picked pilots out of the water when they crashed. And that was our function. We actually were just decoys. The pilots could guide and judge distances from the positions of the various destroyer escorts. And we did training stuff. We fired depth charges and did all that. But the Navy that I was in, the war was winding down, and it was, I think I've told my family many times, it was like McHale's Navy. It's hard for me to believe I was an electrician's mate, but I did master some techniques. I was able to figure out a way to pull the circuit breaker for the refrigeration circuit in the officer's wardroom, and doing that, we would get a complaint from the wardroom that the refrigeration was going down, and we would say, well, I'll send somebody up to fix it right away, and we'd send somebody up with an empty toolbox, and they'd go in the refrigerator and get melons and pieces of cooked chicken and all kinds of good food and bring it down to the engine space, and we'd eat it, put the circuit breaker back, and let them cool down their refrigerators again. And I wound up with a ship getting decommissioned down in Green Cove Springs, Florida, in the St. Johns River. The destroyer escort squadron that I was with we were the 191, the USS Kaufman. The keel was laid in Bayonne, New Jersey, and the ship went out to sea in 90 days, so that's how long it took to make them. The 189 was the USS Bronstein, and as I understand, that was named after a doctor here in Manchester who had served in the Navy in either World War I or World War II. I learned that later in life. But I was discharged from the Navy on a memorable day. It was the 4th of July, Independence Day, 1946, and then back to college.
Bill, one thing I admitted. Bill, I'd like to direct your attention to the time you were in Boston University Law School, and I think you had the very famous professor, Thomas Lambert.
Yes, Thomas Lambert could really energize a class. He was intellectual, he was professor, he was lawyer, and in that mix was a large part of actor. And he could really make the law live, and he had exciting lectures and exciting classes, and he was probably one of the more inspirational teachers that I think any person could have wherever in studying law. He was a delight, and his classes were highly sought after. And I remember many of his lectures very well. Lots of hypotheticals, very, very colorful language, and exciting classes. So of all my years in law school, all three, Lambert is the professor who stands out.
Before we move on to the New Hampshire Supreme Court, when you were appointed in 1981, could you talk to us about the Seabrook appeals?
Well, as some may know, at some point in the 1970s, there were some massive demonstrations down at the site of the Seabrook nuclear energy plant. And some of the demonstrations involved the actual occupancy of some of the land that was designed for the site, and the title of the land was in the name of the Public Service Company. And hence trespass cases arose from time to time. But at one point there was a massive demonstration. Hundreds and hundreds and hundreds of people violated the lines and had a presence on the property. And they were arrested for trespass. They were in many instances incarcerated, and I believe that Judge Bounds was then the U.S. District Court judge. And he became involved when perhaps some claims were made about the conditions of their confinement. I'm not certain, but I can remember Judge Bounds was driving around the state looking at these people who were being confined in places like the Concord National Guard Armory. I mean, they didn't have enough jail space in the state to put them all, but that was neither here nor there. They were all prosecuted for trespass. And the situs, of course, was in Rockingham County. A lot of interesting law came out of these cases, not the least of which, as I understand, was the case involving the Wentworth jury instructions on reasonable doubt. But in any event, they were all processed through the district court system, and everyone filed an appeal. So at one point in the Rockingham County Superior Court, there were 1,700 appeals pending, each defendant asserting his right to a jury trial. The clerk was one of the great lawyers in New Hampshire, one of the great court administrators. That was Anwar J. Samaha. And I think that Anwar always knew what he was doing. And you can call this astute administration, or you could call it benign neglect, but those cases weren't scheduled. And a term would go by, and those appeals weren't scheduled. And time went on, and time went on. And finally, the Chief Justice of the Superior Court, Richard Dunphy, decided that the time had come to have these cases heard. I think you have to imagine that the administration of the trial of those appeals would be an administrative and financial nightmare. Questions were raised as to whether or not a jury, having sat on one Seabrook appeal, could then be impaneled to sit on another where the witnesses might be the same, the situs might not be the same, but there were instances claimed where the prosecuting officers in one case might be required to be at the same time in 2 or 3 places because Judge Dunphy had in mind trying these cases in the 2 courtrooms in the Superior Court in Exeter and in a trial courtroom in Portsmouth, and I think 1 or 2 other places. Logistically, I think the sheriffs were just presented with a mind-boggling situation. So the cases were continued one more time, and I was assigned down there in the summertime to do a summer session, and I was associated with one of New Hampshire's great lawyers and great judges, Wayne Mullavy. And Wayne and I had the summer term down at Rockingham. And lo and behold, one of these, I think the cases that had been reduced to about 14 or 1,500, one of these appealing defendants filed a motion for dismissal based on the grounds that the state had not afforded a speedy trial. And after a lot of discussion, Judge Mullavy and I decided that the motion probably was well-founded, but it would not be appropriate to grant it in the abstract. So we prepared an order, and with one stroke of the pen, we dismissed 1,500 cases. We didn't do it without letting Chief Justice Dunphy know what was going on. And he wanted a little time to think it over. And I can remember he had us consult with a couple of other senior judges in the court at the time, Judge DeClerico and Judge Can. We met up in Laconia at Chief Justice Dunphy's office, and we decided that this was the proper thing to do. So we seized the moment, and Mullavy and I signed the paperwork, and we dismissed all the appeals. And I think probably one of the happiest people at that point were the county commissioners in Rockingham County and probably the sheriff. I mean, the cost of prosecuting those appeals and paying the jurors and transporting them would just be off the chart. But the cases had been waited too long, and the proper case was made for them to be dismissed. It just took somebody to do it, and we did it.
I think it was in 1981 you were appointed to the Supreme Court?
Yes.
And who was the governor?
Hugh Gallen.
Okay, great. And I'd like to get in some of the landmark cases that we have discussed before. And the first one is State v. Ball.
Forrest Ball was a defendant in a marijuana possession case. And the question was one of probable cause for there to be a seizure. The arresting officer, if I remember correctly, had seen a hand-rolled cigarette in the ashtray, and without any evidence concerning hand-rolled cigarettes in the abstract, he seized the cigarette, and it was offered in evidence. and he was convicted in the trial court, and his lawyer was Mark Larson, and Mark raised on appeal the issue of the nature of probable cause and its requirements, not in accordance with the United States Constitution, Fourth Amendment, but with the New Hampshire Constitution. And you have to bear in mind that at that time there was in the legal literature of the day a very, very fine article published in 1977 in the Harvard Law Review, written by Justice William Brennan, making an appeal to the resolution of civil rights disputes on the basis of state constitutional law. And fairly contemporaneously with that, we had the benefit of a decision from Sandra Day O'Connor in the United States Supreme Court case in Michigan versus Long, where she actually encouraged states, if they could find independent state grounds constitutionally to resolve matters, then no federal question would be presented. And, you know, Justice Douglas was on the court at the time. He was a great proponent of this move suggested by Justice Brennan. And so it came to be that Forrest Ball's case was the case where we adopted the doctrine in New Hampshire of state constitutional primacy. I feel very good about that because New Hampshire, it was an early on thing. New Hampshire has become kind of a jurisdiction leader in the country. Many, many states now fall in line with the rationale of Ball and the Brennan Law Review article. The beneficiaries, I think, have been the citizenry and as well as the federal system, because so many cases now can be resolved at the state level without having to have citizens have to have their rights defined in the first instance by the federal courts. And, you know, historically, I think you have to pretty much recognize that civil rights in New Hampshire were defined in our Constitution as part of Part 1. And civil rights in the federal Constitution were the first 10 amendments. I mean, it was a selling point to get the Constitution adopted in the first place. So state constitutional primacy just plain makes sense. And it has created a substantial body of law in New Hampshire, and the citations of State versus Ball number in the hundreds and hundreds and hundreds. In obviously all of New Hampshire's constitutional jurisprudence about primacy, and also in a lot of other states. So Ball was an important case early on in my being on the Supreme Court. Some business magazine, I think last year, suggested that someone write about the most important cases of the New Hampshire Supreme Court during the last century, and the two cases that were given a lot of attention were Claremont and Ball.
Yeah, what about State v. LaFrance?
State against LaFrance was an interesting case in this respect. And I guess, you know, at this point, he can be pretty free in telling what the background was. Judge Perkins Francis Perkins, was a great judge, was assigned a murder case, and there was a change in venue. And I don't remember the name of the defendant, but he was a person who had killed a guard at the Rockingham County Jail. And his case was to be tried in Belknap County. Belknap County is where Chief Justice Keller had his office. And I know from having been told this by each of them that the defendant in that murder case presented a substantial security threat. And it was thought that the officers who testified should not be armed because there was a fear that this fellow, who was pretty strong and capable, if he could break away from where he was seated, he might wrestle a gun away from somebody. And so for security reasons, in that case, Judge Keller suggested that Judge Perkins require that all the officers who testified not be armed. And that was Cy's ruling, Judge Perkins' ruling. Judge Cann succeeded Judge Perkins in Belknap County a year or two later. And he apparently had some talk with Judge Keller, and they adopted this as a policy that when an officer testifies, he or she not be wearing a sidearm. And so that happened in a number of cases. And one of them was a case that, and I forget what the nature of the offense was, but it involved somebody by the name of Arnold LaFrance. And in that case, Judge Cann required the officers not to be armed with sidearms. I don't know just how the case was postured, but the chief of police, who was the prosecuting officer in the case, refused to go ahead with it because he would not appear in the courtroom unless he could be armed, and there was a big hassle. And to make a long story short, the legislature then passed a statute in effect saying that a police officer could be armed in any court at any time. And then that question became raised. Actually, that was raised in LaFrance's case. And it went down to the Supreme Court on the constitutional issue of separation of powers. And the brief, incidentally, that brief was filed by Philip Loughlin, who represented LaFrance, now the Attorney General. And it was joined, I believe, by 8, 10, or a dozen past presidents of the New Hampshire Bar Association who signed on to protect the judiciary from that legislative attack on the separation of powers. One of the persons who argued for the bar presidents was Richard Upton. And most of the bar presidents were in court when that case was argued, I am told. I did not sit on that case. But it was an important case in New Hampshire's culture of its separation of powers.
You know, as an aside to that case, I forget the defendant's name, but he was so bad that they sent him to Marion, which is the maximum federal penitentiary in Marion, Illinois.
Mm-hmm.
What about the Claremont case? You want to get into that?
Sure. It's pretty hard not to. The exegesis of the Claremont case began a long time ago. There was a case involving the Laconia School Board and the City Council that Judge Kennison wrote back in the late 70s, or at some point in the 70s, where if you read his opinion, and I can't give you the cite, but if you read the Kennison opinion, he's almost imploring the issue of school financing to be raised on a constitutional basis. That was the time that Rodriguez in Texas was in the works, and of course Rodriguez in Texas came down on a 5-4 decision, and that stood for the proposition that the entitlement to be educated was not a federally guaranteed constitutional right, which left these kinds of cases to the states. So in the early 1980s, a man by the name of Jessamine, who I gather was a school student, filed a case before the state Supreme Court claiming that he was entitled to be educated at state's expense under Article 83 of the New Hampshire Constitution, the so-called literature clause. And he was represented by Arthur Niswander, who had been involved in the earlier Laconia case. He was represented by the McLean office. Wilbur Glan was involved. And Judge Cann was the trial judge. And the case came over to the Supreme Court on pleadings early, and it was remanded back to Judge Cann for there to be either an agreed statement of facts or a record made. And while the case was pending, a settlement was reached of sorts. The Jessamine lawyers dropped the appeal before the state Supreme Court because the then governor, John Sununu, and the legislature had put together a package of legislation whereby they adopted something called the Augenblick formula. Augenblick was a professor out in Colorado, I believe, who had devised a scheme of the distribution of state money to needy school districts. And the adoption of the Augenblick formula ended the Jessamine appeal. But like so many things in New Hampshire, the Augenblick formula having been adopted, it was never funded. Now, you know, a deal was made of sorts, and you can't get away with that in the business world. I mean, you can't make a deal and then just plain renege. That's what happened in this case. The Augenblick formula was on the books, but it wasn't funded. So, in fact, and this is the tragedy in this whole background, and you know, it would take a lot of research, but some of the people who voted to adopt the Augenblick formula to avoid the Jessamine lawsuit are the same people who voted not to fund it. Now, if you know, that's not exactly a profile in political courage. I mean, that's political hypocrisy of the worst kind. So against that background, along came the Claremont case. And in the first case was a simple case under our Constitution, Article 83, Part 2, whether or not there was a state obligation to educate. We said there was, and remanded it to the trial court for a trial. And it went back. It was tried, I guess, by Judge Manius. And there was a big record made, a huge record. Judge Manius wrote a 100-page decree or decision. He indicated there was a lot of problems in the way schools are financed. But the bottom line in the Manius holding is a very simple one. He said that, in effect, that the state, even though it had the obligation to educate, could then delegate to municipal subdivisions the duty to finance it. And the case came back, and in December of '97, the so-called second Claremont case came down, and that was the one that stood for the proposition that it was a non-delegable duty. It was the state's duty, and that under our Constitution, taxes have to be proportional and reasonable. It's that simple. And when you have the disparate property tax scheme that New Hampshire has witnessed with ever-increasing disparities over the last 50 years, the decision was almost self-executing. I think I was mentioned in the press as having said it was a no-brainer at some point. I guess it's traumatic for the legislature to have to deal with it, but the 1997 decision reflects the holdings of the New Hampshire Supreme Court in its tax cases over the last 150 years. I mean, there's nothing that's changed. It shouldn't come as any great shock to anybody or any surprise. All we're saying is taxes are going to be fair. Now, if the state wants to avoid the consequences, they can amend the state constitution. They can amend it in a way that will guarantee that taxes will be disproportional and unreasonable. And those are the options.
Bill, I'd like to have you go back to when you first started practicing in 1952, the size of the bar and changes you have seen and your perspective on the, as Maureen Manning would say, the olden days and the contemporary.
Well, when I was admitted to the bar, my hunch is there were probably around 400 lawyers in New Hampshire. And now there are well over 4,000. So the ratio has multiplied, there's a factor of 10. The population, however, has, I think, just about doubled, perhaps doubled plus, but the bottom line of that balance sheet, I guess, is that there are a lot more lawyers today per capita than there were when I was admitted. But society, in governing itself, has become a lot more complex. There have been great changes in the way we govern ourselves compared to the government which existed in the 1950s, almost half a century ago. And I think this change in the relationship between the individual and his or her government has been the occasion for the market for so much more legal service and legal talent. I think that people keep saying things were so much simpler in the 50s, and that the lawyers could settle cases over the telephone and work toward settlements and mediations in each other's offices, with or without their clients. I think, sure, that happened, and you and I participated in that kind of a law practice, but it was based a lot on the fact that you knew so many of the lawyers. And it's the personal relationship that engenders the trust. And today, we're doing business, lawyers are doing business with lawyers. They can't put a face on the body. They've never seen this person before. And I think that until a relationship of trust and confidence has been built up, the tendency is to deal more cautiously and at arm's length, because after all, the lawyer's job is to protect his client's interest, or her client's interest, as the case may be. So I don't think the culture has changed. I think today, those lawyers who know each other well can practice law the way we did 50 years ago. But I think there are fewer of those relationships today, hence the practice seems to be a lot more sophisticated and a lot more complicated. I don't think lawyers are any better or worse today than they were 50 years ago. You know, they perhaps are more skillful in, you know, some of the, you know, the adjective impedimenta of the law practice, you know, computers and all that stuff. But I think that on balance, there was a core of lawyers that could be just as comfortable practicing in the 1950s as they are comfortable today, and vice versa.
There's another case that you had, the Canelo case. How do you spell that? You know?
That's C-A-N-E-L-O. Canelo is a case which actually I think had been mooted, but the Attorney General asked that an opinion be rendered. And I forget the underlying facts, but the proposition is a very simple one, and that is on the basis of state constitutional law and state constitutional primacy, New Hampshire today, different from its pre-Canelo days, has adopted the exclusionary rule as a part of its state constitutional law, and has, at least in that case, not permitted the good faith exception to the exclusionary rule. In a fairly understated way, it's a pretty important case in New Hampshire. But only those who practice in that area would be conscious of its significance.
Bill, today is July 27th, year 2000, and the media has said that we have a crisis in the court. I'd like to direct your attention to the impeachment of Chief Justice Brock and any comments you may have on it.
Oh, I think I have to start by saying that, in my view, now bear in mind these are my personal views based on experience, there is no crisis in the court other than what has been created by the press and the legislature over recent weeks and months. I left the court in '95 and was replaced by John Broderick, who was an extraordinarily intellectual and capable and good-hearted judge who has the potential for being one of the great judges in our country, I believe. He's a very decent and honorable man. But I have watched the events, as we all have, of recent months, and I think if there were ever a lesson to be learned from the law of unintended consequences, is to be learned in what's happened to the judicial system recently. When this first broke, you know, this story first started to get legs in the press, a young reporter called me and said, you know, well, Judge, what do you have to say? And I said, well, I didn't see this in print later on, however. I said that in all of things of this nature involving, you know, the players here, there are two victims. The first victim is the truth, and the second victim is the relationship between and among the three branches of government. And I think that pretty well sums it up. I have seen and heard and read so much activity about the participation of disqualified judges in the decision-making process of the court that I really can't believe what I'm seeing, hearing, and reading, because it just plain does not happen. A letter was written by Howard Zibel to the governor, the speaker, the Senate president, and the attorney general on the 3rd or 4th or 5th of April. And he said, hey, I filed this report, but I want you to know that the only time anyone has crossed the line was when Judge Thayer did so in 2 cases. It just doesn't happen. These are the only 2 events. He's paid an horrendous penalty for that transgression. And Zibel goes on to explain all this, and apparently nobody paid any attention to that letter. I sense that there is great animus in the legislature toward the judicial branch, particularly the Supreme Court. Unfortunately, it's misplaced, but I think, unfortunately, it has its seed in the Claremont decisions. I mean, all these people say, oh, that's got nothing to do with it. That's, I think, you know, in some cases probably that's true, but I think there's a great well of hypocrisy there. After all, I am told that a person who was seeking some nomination for public office this year in a fundraising letter sent out long before any of this happened, aimed as one of his or her objectives in the letter that the impeachment of the Chief Justice, you know, for what reason? I am satisfied that the court is going to survive this. I am very distressed when I see people talk about an erosion of the moral authority of the court. I don't think there should be any. I don't think really there is any from people who really know and care. The moral authority of any court is its jurisprudence, and I testified to that effect before the legislature's committee, the Judiciary Committee. And New Hampshire's jurisprudence thus far has been good and strong and very respectful of the rights of all our citizens, and I think that's the source of the court's moral authority. I don't think the fact that somebody may have made a mistake in judgment erodes moral authority of the court's decisions. And if you look at what's before the Senate right now, I can't believe that any one of the items which the House Judiciary Committee has served up, and the legislature as well, comes within light years of being an impeachable offense. The process will play out, and I would hope that calm judgment will prevail in the Senate, and hopefully the majority of them, or whatever may be required, will determine that I am right, that none of this rises to the level of an impeachable offense. I don't know what I'm going to do when I testify. I am tempted to I am tempted to tell the Senate, the Attorney General, the House Judiciary Committee, that I will waive any statute of limitations, whether it's in the criminal statutes or the Code of Judicial Conduct. If they can find that I have done anything wrong, let them come ahead with it. I am sick and tired of watching people on television say they all do it, meaning disqualified judges participate in decisions. They don't all do it, and that's the lie. David Brock hasn't done it. Bill Johnson hasn't done it. Sherm Horton hasn't done it. Steve Thayer has, and he's got in trouble over it. And I would like to think that, I mean, even the House Judiciary Committee couldn't bring itself to...
Can I interrupt a minute?
Yeah.
You meant to include John Broderick, didn't you?
Oh, yes, but
Yeah.
see, I didn't sit with John.
Oh, I see.
He succeeded me.
Yeah.
Obviously,
Okay.
I mean, I'm sure John Broderick would never touch that. So I'm very distressed that that's what's happening. I am also distressed that members of the bar, responsible members of the bar, are giving opinions about the merits of the underlying matters. They haven't heard the case. If any judge did it to one of them after half the case is in, they'd be in orbit. David Brock has not put on one witness. Not one of the state's witnesses or the legislature's witnesses has been cross-examined. Not one. And the evidence which the government has at its disposal right now is a huge pile of evidence that has been gathered by an array of leading questions that could not, under the rules, be challenged. And for a lawyer with that in the scales to make opinions and judgments about the ultimate question is just beyond my comprehension.
Bill, this may be a hot potato, and you may not want to get into it, but do you want to make any comments about our Attorney General? Or would you rather just...
Well, I have made these comments before in public. On the 31st of March, Phil Loughlin had in hand the resignation of Stephen Thayer. And that ended that sad chapter. And I have some feelings for Steve. He was in a very difficult situation, but he made bad matters worse. That, if you look at this, we in the court get, as you know, our power and our authority is derived from the Constitution and the people. The Attorney General's power is derived from the legislature. There's an enabling statute. And if you read that statute, you'll find out that his job is to represent the state before the Supreme Court and to prosecute crimes. In McLaughlin's report, which he issued on the end of March, he said no crimes were committed. Well, in my view, that's when his job ended. I mean, he had Steve Thayer's resignation, and he'd made a finding that no crimes had been committed at the court. But then he went on and made these gratuitous offerings about the recusal policy. And I just think if he had said, okay, I don't have all the information on this score, I better check it out a little bit further, I think he could have done that. And I can't believe that he ever intended the consequences that have come about as a result of that report. But as I said at the outset, the two victims here, one is the truth, and one is the relationship between and among the three branches of government. And we're going to have to watch it play out. If the truth prevails, if common sense governs, if the senators do their job, they should find that, as I said earlier, that whatever David Brock's conduct may or may not have been, it doesn't come within miles of being an impeachable offense, and this matter should come to an abrupt end. But it's a political judgment, and I'm not going to make predictions.
Is there anything further you want to say on either?
I've said too much already.